It's November 2009. A 36-strong constellation of communication satellites known as Iridium is orbiting the Earth at an altitude of around 600 kilometers. These satellites are part of a commercial network providing data services to customers across the globe. The constellation is owned by Iridium Communications, headquartered in Maryland, USA. Also in orbit is a defunct Russian military satellite, Cosmos 2251, which was launched back in 1997. It's been dead since 2005, but it remains in orbit as space debris. Then disaster strikes. The two satellites collide. This is a huge deal. It's the first time ever that two active satellites have collided in orbit. The question is, what happens now? Who's responsible for the damage? And if one party is found guilty, how do you make them pay? Here on the Legal Eagle, we help you understand law wherever it can be found, including out there in the cold expanse of outer space. According to Article 1 of the Outer Space Treaty of 1967, to which all parties involved are signatories, outer space, including the moon and other celestial bodies, is not subject to national appropriation by claim of sovereignty, by means of use or occupation, or by any other means. That means that no country owns outer space. But does that also mean that they can do whatever they want up there? No. Not if they're launching a satellite, rocket, or any kind of spacecraft. They must take all possible measures to avoid harmful contamination of other states. And that includes making sure that dead satellites don't just stay in orbit, but rather that they deorbit in a timely fashion and burn up in the Earth's atmosphere before they become a danger to other spacecraft. But Cosmos never did this. The satellite was launched by Russia, but it never came under Russian control after its initial launch. Instead, it remained under the control of the manufacturer, the French-based company Astrium. Although the company tried to develop a plan to deorbit the satellite, it never came to fruition. And so, in the absence of any international court with jurisdiction over such matters, we seem to be left with nothing more than a gentleman's agreement that if you launch something into space, you're responsible for it until it comes back down. But that doesn't really cut it. If the liability falls on the launch nation, then who decides whether or not that nation has acted negligently, and who decides how much the damages will be? This is where things get complicated. The head of the investigation into the crash was conducted by the United Nations. As required by international law, the UN report concluded that the incident occurred due to the failure of ground controllers to implement corrective measures. In layman's terms, the satellite operator failed to move the satellite out of the way of the debris. And in the report, Russia claimed that under international law, the satellite operator was liable for the damage caused to the Iridium satellite. However, the report noted that the amount of compensation would depend on the amount of damage done and the applicable law, neither of which had been determined. And so the matter goes to court. Before we get into the courtroom drama, let's take a quick look at some of the facts of the case. The two satellites were worth a combined total of $78 million. As a result of the collision, 6 of the Iridium satellites were rendered useless. Each of these cost approximately $45 million. One of the remaining satellites was damaged but could still operate at reduced capacity, and one suffered minor damage with no loss of function. The 4 satellites that were not damaged at all were shifted to new orbital positions to mitigate the risk of further collisions. And now back to the drama. The US and Russia decided to negotiate a settlement between themselves before going to court. However, the negotiations fell through when they couldn't agree on who was responsible. According to Russian lawyer Sergei Korzunov, Russia refused to compensate Iridium because, according to the Outer Space Treaty, only the Russian government, not Russian citizens or corporations, could be held liable. And so the case went to court. In 2013, the International Court of Justice in The Hague delivered its verdict. The court ruled that the Russian Federation, the government, is liable for the damage caused by the uncontrolled re-entry of the satellite Cosmos 2251. However, the court stopped short of saying whether the government was liable for the satellite being in orbit in the first place. Instead, the court found that Russia was only responsible for the damage caused by the uncontrolled re-entry of the satellite into the Earth's atmosphere. Iridium argued that Russia should have made every reasonable effort to bring the satellite down immediately after its operating life ended in 2005. By failing to do so, Russia was negligent. Russia countered that its obligations ended after the satellite was decommissioned, and that it was unresponsible for the satellite's subsequent behavior. While acknowledging that Russia had violated the Outer Space Treaty, the judge ruled that the court was not competent to determine the amount of compensation to be paid, leaving the door open for further negotiations between the two countries. While the ICJ looked at the legality of space debris and liability for space objects, another court was looking at the safety of astronauts in space. In 1997, NASA astronaut Jerry Lininger was aboard the International Space Station when he was struck by a piece of debris, seriously injuring his hand. The object that hit him was later identified as a piece of a second-stage booster from a Chinese rocket that was launched 3 years earlier. China hadn't informed the world that the rocket's upper stage would remain in orbit, nor did they tell anyone when it would come down. Because of this, NASA filed a lawsuit against the People's Republic of China for negligence and strict liability in the U.S. District Court for the Eastern District of Virginia. Under the former, it was alleged that China's failure to establish and implement a system to track the upper stage rocket and to notify the international community of its presence in orbit fell below the standard of care that a reasonable state would exercise in managing its space activities. Under strict liability, the court was asked to find that China was liable for the injuries sustained by the astronauts simply because a Chinese rocket caused the injury without regard to fault or causation. This was a hard case to prove in court. China didn't admit jurisdiction, nor did it submit any evidence in defense of the case. China also refused to answer written questions submitted by NASA and insisted that any testimony by its representatives be given only in Mandarin Chinese. To make matters worse for NASA, the US had no diplomatic relations with China at the time. In 1999, the court ruled in favor of China, finding that it was immune from suit in US courts based on its status as a foreign state. Later that year, the US Court of Appeals for the Fourth Circuit agreed, stating that the court lacked jurisdiction to hear the case because China had not waived its sovereign immunity. So the case was thrown out. NASA then appealed to the Supreme Court, which ultimately agreed with the lower court that China was immune from suit in US courts. However, the court left open the possibility for NASA to sue China in an international court. After the Supreme Court's ruling, the Chinese government stated that it was willing to negotiate a solution with the US government. China also announced that it would begin tracking upper stages of its rockets to improve the safety of space activities. However, in 2000, the US decided not to pursue the matter any further. Perhaps it was simply easier to drop the lawsuit than continue fighting it. Or maybe the US was concerned about damaging its newly established diplomatic relations with the rising superpower. Either way, the lawsuit was dropped. When it comes to dealing with space debris, there are two main issues. First, who's responsible if something bad happens? And second, how do you actually collect money from that party? Dealing with the first issue is fairly straightforward. There are a number of international treaties and agreements that set out guidelines for how states and non-state actors should behave in space. For example, the United Nations has a set of guidelines for the long-term sustainability of human space activities. These guidelines call for states and non-state actors to take all appropriate measures to minimize the creation of space debris and to ensure that space debris does not pose an unacceptable risk to international space activities. However, dealing with the second issue is much more difficult. How do you collect money from a foreign government if it is found liable for causing damage in space? The answer is that there is no easy answer. In most cases, it is simply not possible to collect money from a foreign government if it is found liable for causing damage in space. This is because most countries are immune from suit in the courts of other countries. And even if they're not, it's usually very difficult to get a judgment against a foreign government. For example, in 2009, a US court ruled that China was liable for damages caused by a piece of debris from a Chinese rocket that hit a US satellite. However, the court found that China was immune from suit in the US courts and the case was thrown out. Similarly, in 2013, the International Court of Justice ruled that Russia was liable for damages caused by a Russian satellite that collided with a US satellite. But again, the court stopped short of awarding damages because it said that it did not have jurisdiction to do so. So what does this all mean? Well, it means that right now there is no effective way to hold countries accountable for their actions in space. This is obviously a problem because as more and more countries launch satellites and other spacecraft, the risk of collisions and other problems increases. At some point, it's likely that someone will be held liable for causing serious damage in space, and when that happens, it's not clear what will happen. But one thing is for sure, it will be a messy affair. Do you think there should be a way to hold countries accountable for their actions in space? Let us know in the comments below. And as always, thanks for watching The Legal Eagle.